Our proposal now is to listen to the lawyer's perspective. We welcome Margarete von Galen. She is the president of the Council of Bars and Law Societies of Europe. And I think that, good morning and welcome. You are bringing us a vision on how important for lawyers can be the digitalization of justice in Europe. You are joining us from Germany. Please, good morning and take the stand.
Good morning and thank you very much. And let me first thank you on behalf of the legal profession of the European Union to invite the Council of Bars and Law Societies of Europe, the CCBE, to participate in today's discussions. And just want to indicate the CCBE is recognized as the voice of the European legal profession, representing the bars and law societies of 45 countries, and through them more than 1 billion European lawyers. And as you already said, I think it's important to have the view of the legal profession in this conference, even if I might have to pour some cold water on the matter. Also for us, it's no longer a question of whether our environment will become more digitalized, and this reality has already happened. And we also, of course, see that digital justice can facilitate greater access to justice for everyone, and it is essential that it facilitates those who need it most. The CCB has always welcomed EU initiatives on the digitalization of justice, as they are a way to foster interoperability and different national systems. And of course, they also are a useful tool for lawyers that, if properly managed, could allow them to organize their work more efficiently and significantly improve their clients' access to justice, including better and faster justice, which of course is also the lawyers and the client's interest. Nonetheless, the CCB has also stressed that any perceived need to increase efficiency through the use of technology should not sacrifice the consistent delivery of justice. Hence, safeguards must be adopted to guarantee that the implementation of eJustice systems does not jeopardize the independence of the judiciary and the right to a fair trial. Therefore, lawyers must remain consulted and structurally involved at policy and implementation level in relation to any initiative on the digitalization of justice, as they represent one of the main user groups of eJustice systems. eJustice needs to consider lawyers' requirements and obligations in terms of deontology, data protection, professional liability, or rules of evidence. For instance, lawyers must have access to the eJustice systems in other member states, including tools to access electronic evidence in a cross-border context. Professional secrecy obligation must be respected when developing systems that improve cross-border access to electronic evidence. This is one of the most important shortcomings of the e-evidence proposal. Unlimited access to data shall be possible, and there is no technical tool to identify and separate lawyer-client data, which, in an offline world, would be protected by the right of the client to confidentiality. Hearings through video conferences must ensure the possibility of lawyers to talk confidential with their clients during the hearing. The technical arrangements in place for the use of video conferencing should ensure as much as possible a true-to-life hearing experience, including full communication and interaction of all the parties to the procedure. Electronic signatures and seals on submissions from lawyers must be easily verifiable in cross-border cases in all countries, and the technical requirements must be harmonized in the member states. In view of these examples, we see a need for EU-wide minimum standards to ensure that national and EU e-justice systems are able to guarantee rights to a fair trial and take into account the specific needs of all stakeholders involved, including those of lawyers. And in this context, e-Codex deserves particular attention due to its high importance for the future of the legal profession. The CCB strongly welcomes the proposal for a regulation which has been presented by the European Commission on the e-Codex system, and also, of course, its handover to EU visa. However, such proposal must be supported by sufficient safeguards. It is absolutely essential that lawyers remain involved in the future development of such an important tool as eCodex, as we are one of the main users. And in this regard, the CCB welcomes the recognition of the involvement of the legal professions and other stakeholders in the governance of the eCodex system within the work of the advisory group and the program management board. However, we think that some clarifications might be needed regarding the conditions and the effectiveness of such involvement. And along with these considerations, the CCB calls to maintain the independence of the judiciary and the right to a fair trial in the development of the European eJustice infrastructure. We welcome the creation of the specific governance in the eCodex proposal. However, also to this regard, the CCB asks for clarifications on how the proposed governance structure will effectively ensure the independence of the judiciary in practice. The proposed regulation might need stronger requirements to ensure this principle, such as a clear separation of services and personnel and data and administration inside EU visa to ensure a clear separation between the justice side and the home affairs and law enforcement side. Let me also say some words on artificial intelligence. With the great benefits offered by technology also comes a great responsibility to ensure that the use of technologies in justice remains ethical, fair, and human-centered. And it is of paramount importance that such considerations are also taken into account in the development of the use of artificial intelligence in our judicial systems. Much debate, as we think, is still needed to critically assess what role, if any, AI tools should play. Change should be embraced where it improves, or at least does not worsen the quality of our justice systems. AI systems should be introduced only when there are sufficient safeguards against any form of bias or discrimination. Moreover, we firmly believe that minimum safeguards and principle, also with regard to AI, should be upheld to counter the potential risks and impact of AI tools within court systems. And I would like to identify these principles, which is the principle of identification, which means the possibility to identify the use of AI. All parties in a judicial process should always be able to identify prior or within the judicial decision the elements resulting from the implementation of an AI tool. Then there's the principle of non-delegation. Under no circumstances should the judge delegate all or part of his or her decision-making power to an AI tool. In any case, the right to a human judge should be guaranteed. The principle of transparency, which is the possibility for the parties to verify the data input and reasoning and functioning of the AI tool. The principle of discussion, which is the possibility for the parties to discuss and to contest AI outcomes in an adversarial manner outside the deliberation phase and with a reasonable time frame. And finally, the principle of neutrality. The neutrality and objectivity of AI tools used by the judicial system should be guaranteed and verifiable. So I come to conclude. We firmly believe that our efforts should be centered around how digitalization can benefit society in the long term by focusing on improving the quality of justice from a user perspective. One must remain vigilant that digitalization efforts stay focused on improving the quality of our justice systems and are not only introduced for achieving efficiency gains or cost savings. This requires a structural dialogue and collaboration among all justice stakeholders, such as EU institutions and agencies, national ministries of justice, judges, councils of the judiciary, court staff, and especially legal practitioners such as lawyers. And therefore, the CCBE proposes to establish a kind of high-level expert group on the digitalization of justice and the use of AI in justice as an advisory body to the European Commission. This expert group should involve all justice practitioners. It could consider the various challenges regarding the digitalization of justice and offer the necessary intellectual and ethical guidance, not only from the perspective of the administration of justice, but also from a users and practitioners' point of view. So finally, thank you very much for giving me the opportunity to address this audience. And I listened, which were very much interest. I was listening to the speeches this morning, but what became apparent that while the user's perspective and also the user's perspective with regard to rule of law and the stakeholders who are very important with regard to the rule of law, which are is the legal profession, which are the lawyers, have not, I must say, have not been mentioned. And I think, of course, every presentation was very interesting and it's very much about technical issues, etc. But please, I would be very happy if you can just take home the message. There is a very big user community outside in the European world where the lawyers play a crucial role. And thank you very much for involving us as it is as much as possible in the near future. Thank you.
Thank you very much, Margarete. Thank you for your specific remarks on reminding us all what's the justice for and how many different rules, professions, and people surrounds all the system and how sensitive it is.